Yes, good morning, Commissioners. As I know you are all aware, last week, both the U.S. Attorney's Office and the Attorney General's Office announced indictments against 3 individuals associated with FBT Realty in Everett. Those individuals are Dustin D'Annunzio, Anthony Gattineri, and Charles Lightbody. As with any indictment, these are allegations which need to be proved beyond a reasonable doubt in a court of law. The state indictments include impeding a gaming investigation, conspiracy, and tampering with evidence. The federal indictments include conspiracy, aiding and abetting, and wire fraud. In addition, the federal authorities have also moved for forfeiture of the proceeds derived from the alleged criminal conduct. I have asked the commanding officer of the Massachusetts State Police Gaming Enforcement Unit, Detective Lieutenant Brian Connors, to address the Commission regarding the investigation. I would once again like to compliment Detective Lieutenant Connors and his team, particularly Lieutenant Kevin Condon from the State Police and Guy Michael and Robert Carroll from our consultant firm of Michael and Carroll for the fine investigative work they did on this issue. I am also grateful to the FBI, the U.S. Attorney's Office, and the Attorney General's Office for their efforts and collaboration in this matter. So I'll turn it over to Detective Lieutenant Connors to address the Commission.
Thank you, Director Wells. Good morning, Commissioners.
Good morning.
It's a pleasure to speak to you here this morning. I'll try to keep my remarks brief, but I do want to hit on several points, specifically 3 main areas that I'll provide some details during my remarks this morning. The first area that I'd like to highlight, and this is from the IEB's perspective, is that the investigative process leading to these indictments worked, and it will continue to work. The second note is that the process worked, will continue to work in a large part due to the cooperative law enforcement efforts involving the State Police, the IEB, the FBI, the Department of Correction, the Attorney General's Office, and the U.S. Attorney's Office. And the final point, I'd like to highlight these specific roles of the IEB, not only in this investigation, but investigations in general, including the regulatory versus criminal investigative aspects of our duties. I believe that last point is critical to shed some light on just really what the function and roles are of each agency, particularly in an investigation of this nature. To that last point, during early July of 2013, the State Police assigned to the Investigations and Enforcement Bureau of the Massachusetts Gaming Commission received information from the Federal Bureau of Investigation relative to the suspected hidden interests of a convicted felon in the Everett land, which was the proposed site for the Wynn Casino. At that time, IEB investigators were in the midst of the suitability investigation pertaining to the Wynn Mass LLC application, which also included investigating the proposed land deal between the Wynn Mass LLC and members of the FBT Everett Realty LLC, the owners of the property. During the ensuing months, IEB investigators, led by Lieutenant Kevin Condon, who is present with me today and seated to the left of Director Wells, furthered the IEB's regulatory investigation, which included gathering additional evidence. It's important to detail that the IEB's primary function is to conduct a regulatory suitability investigation, while any criminal matters uncovered during that process are referred to the Attorney General's Office, or in this case, also the U.S. Attorney's Office. This framework has been put in place by statute and provides a blueprint for the IEB and the AGO's Division of Gaming Enforcement to operate from. It is important to note that there is a distinct line between the gathering of evidence from a regulatory standpoint versus the gathering of evidence in a criminal investigation. The limitations between the two and the accompanying legal requirements are to be strictly adhered to. This distinction is one that the IEB and our state and federal counterparts took very seriously and maintained throughout this investigation, and will continue to do so going forward. The separation of functionality is critical to the integrity of both the regulatory investigation being conducted by the IEB and the criminal investigation being conducted by the Attorney General's Office and the U.S. Attorney's Office. As far back as December 13, 2013, during the Commission's public meeting, and prior to a summary of the investigation by the Investigation and Enforcement Bureau to the Commission, IEB Director Wells prefaced her presentation to the Commission by stating, quote, "Information sharing, particularly between different law enforcement agencies, is critical to ongoing success," end quote. I highlight those words by Director Wells because it is just that level of cooperation that has led the investigation to this point, from the initial information received by the state police and the IEB from the FBI, to the IEB making the required referrals to the Gaming Enforcement Division of the Attorney General's Office, the FBI, and the U.S. Attorney's Office. The regulatory and criminal investigative process in place was expected to work, it has worked, and it will continue to work. During that same public meeting on December 13th, 2013, Director Wells also provided the details of the IEB's investigation to that point, including the circumstances surrounding the land purchase of the current WinMass LLC site and the suspected criminal wrongdoing of the part of a number of individuals. Specifically, Director Wells informed the Commission at that time, and again I quote, "Evidence exists to suspect that Charles Lightbody, a convicted felon, may have retained an interest in the Everett property, and well after the applicant, Wynn, had been advised that he had been removed," end quote. The IEB was well aware of the fact pattern as a result of our investigation to that point, and had been so informed since early July of 2013. It was also during that same public meeting that Commissioner McHugh indicated that the IEB should, quote, "refer everything that we've got to the appropriate law enforcement authorities, the U.S. Attorney, the District Attorney, and the Attorney General," end quote. That is exactly what the IEB did with the evidence gathered to that point, and which ultimately assisted in obtaining the previously detailed indictments obtained by the U.S. Attorney's Office and the Attorney General's Office. The investigative process worked. Since that December 13, 2013 public meeting, Director Wells has continued to update the Commission as to the status of the WinMass LLC application process and ongoing IEB suitability investigation. It is important to note once again that the IEB's ongoing suitability investigation at that point was separate and distinct from the investigations being conducted by the Attorney General's Office and the U.S. Attorney's Office. Again, it was absolutely critical that the regulatory and criminal investigations remain separate and distinct. It is important to point out that the suitability of any applicant or licensee is an ongoing process, either during the application phase or after licensure. Suitability is a continuous process. On May 2nd, 2014, Director Wells updated the Commission by informing them in part that, quote, "the IEB continues to follow through on obtaining relevant information regarding the sellers of that property," end quote. Most recently, on September 8th, 2014, Director Wells again addressed the Commission, providing them with a suitability update regarding the WinMass LLC application, as well as an update relative to the IEB's investigation of FBT Everett Realty LLC, which included a summary of additional information that the IEB obtained since the suitability hearing. This information was also turned over to state and federal authorities. On that date, Director Wells also provided information to the Commission that the IEB had uncovered no additional information that Wynn personnel had knowledge of or participating in any efforts to conceal any information from the Commission. That status remains to this date. In closing, I would like to state that these state and federal indictments, as outlined by Director Wells, generally provide us with facts that were consistent with the IEB's investigation at the time the evidence was referred to state and federal authorities in 2013. The ensuing state and federal investigations corroborated much of what the IEB learned during our own investigation. Going forward, I believe that these cooperative efforts and the results to this date clearly demonstrate that the Massachusetts Gaming Commission and the citizens of the Commonwealth can have full confidence in the state police, the IEB, and our state and federal counterparts. Again, I thank you for the opportunity to speak to you today. I'll turn it back over to Director Wells for additional remarks.
Thank you, Detective Lieutenant.
Thank you very much, Detective Lieutenant Connors. I'd also like to add, as I reported to the Commission during the suitability update on September 8th of 2014, we have confirmed with Wynn that the individuals who were indicted last week will have no involvement in the casino operations going forward. I think it's important for the public to understand that being honest and forthright with the Commission is of paramount importance. With that in mind, I do have a message as we go forward in this process that I would like to read into the record. As we move forward with the implementation of the Expanded Gaming Act in Massachusetts, the Investigations and Enforcement Bureau will not only be continually monitoring the suitability of licensees, but we will also be investigating potential vendors and employees, as well as applicants for Region C. The events of last week underscore the continuing validity of the principles of integrity and honesty, which are the cornerstone of our investigations. As such, I have 3 pieces of advice for individuals who we come across during these investigations. Piece of advice number 1, do not lie to commission investigators. It would be foolish to assume that we will not figure it out. Our track record speaks for itself. My second piece of advice, do not lie to commission investigators. Honesty is the best policy. If there is a problematic issue, the commission will work to see if there is a fair and reasonable solution. And not surprisingly, my third piece of advice is do not lie to commission investigators. Lying to commission investigators is a crime, and we will refer concerns to state and federal criminal law enforcement authorities. The role of these authorities is to proceed with a criminal investigation where appropriate, and make no mistake, they will. So we are certainly happy to answer any questions that the Commission has at this time regarding these matters.
Colleagues? Well, let me just come back and look at the distinction. Ask a question of you, Director Wells, about the distinction between regulatory investigations and criminal investigations that Detective Lieutenant Connors talked about. I take it that distinction not only lives in the statute, but also is consistent with a fairly well-defined case law, judicial distinction between rights that parties have and rights that the state has when we're dealing with a regulatory investigation as opposed to a criminal investigation.
That is absolutely correct.
And it's important to keep that distinction firmly in place in order to assure that individuals have their constitutional rights, but also in the regulatory arena that the Commission has freedom to act and act broadly to preserve the public interest.
That's correct.
It seems to me that unless others have questions, that the bottom line on this, my takeaway from both the report that we received today and looking at the indictments themselves, it really falls into 4 related parts. The first is that the Investigation and Enforcement Bureau's investigation concluded, and the indictments reflect that the Wynn applicant had no role in any wrongdoing by the owners of the land and had no knowledge of that wrongdoing before the investigation was completed or at least commenced. Secondly, that the FBT sellers and the personnel involved in that company will have no ongoing involvement with Wynn operations when Wynn operations begin. In fact, have no ongoing involvement with the Wynn applicant once the land sale is consummated shortly after the license is awarded. And the third of those is that if any lies are proved, and if those lies led to the receipt by FBT members of money, then under the federal indictment, that money is subject to forfeiture to the federal government. And finally, if there were lies, but those lies did not lead to the receipt of money, then the people who told the lies still face substantial prison terms, a possibility thereof, for lying, regardless of whether or not the lies produce money. So it seems to me that the integrity of the system did work and has worked and continues to work. Now, we got a letter yesterday from Attorney Charles Baker of DLA Piper that talked about some of these same things. I got that letter I got it at 5 o'clock yesterday afternoon and have only had a chance to look at it briefly, but it seems to me on that brief first glance that there's nothing inconsistent with what we've just discussed here today in that letter. But we will, of course, as we do, give everything careful consideration and in due course. But it's important to understand that in addition to the report that we've received today and the prospect of future reports, because suitability is a continuing obligation and responsibility of the Gaming Commission and will be adhered to. The Gaming Commission as a whole is going to monitor carefully the progress of this applicant's movement toward operations, toward opening, just as it is today monitoring the movement toward operation and opening of MGM and Penn National. We're having 30-day reports, we're having conferences, we've got a consultant who's overseeing their operations, and we'll continue to monitor activities as they proceed and make adjustments if and to the extent necessary in the conditions that we've set out as circumstances revealed by that monitoring warrant. We've already made adjustments. We've already requested and demanded changes to various plans in the ongoing operations of our licensee and licensee designate, and we'll continue to do that here. So that, it seems to me, is where the matter stands now. Indeed, the first presentation by WIN, the first requirement that they appear and give us a report, is in simply a few weeks away, and so we'll have a chance to see how that plays out then. So that's my view and synopsis of where we are today. I welcome any additional thoughts from my colleagues. Commissioner Zuniga?
Sure. I'm in full agreement with your summary. I thank you for the presentation and the emphasis on how it's distinct to think about the regulatory investigation and the criminal investigation. I think that's key for us to understand, for our audience to understand and appreciate. It's clear that you started with this process more than a year ago, and you took the regulatory investigation as far as you could. And at that time, you turned over to the appropriate criminal law enforcement authorities, and they have taken action. And I think this reflects very much what you suspected. And your 3 pieces of advice that could be essentially 1 piece of advice should not go unnoticed by anybody who's watching, because that itself is an offense that might be punished with prison sentence. So I also want to emphasize, as it's been said here, I'm comforted that your thorough and detailed investigation did not uncover any role of the WIN applicant in the effort to conceal this ownership. And I think that also speaks volume to the process, volumes relative to the process. So thank you for the update, and thank you for the work you do.
Yeah, I would just echo what my colleagues said. I think one of the key words that stuck out for me in this presentation, I think, was by the detective lieutenant saying that the investigative process worked. And I think it's helpful for people to understand, again, from this presentation, that the IEB is a new creature created out of the gaming statute with assigned responsibilities and authorities and powers. And again, I also think that it worked, and as it's been raised here before, suitability is an ongoing process. We know that in the coming months we'll have new qualifiers who are currently being reviewed by the IEB, so it's not just once you get a license or designated for a license that the suitability test ends there. I do have a question for Director Wells, and it's just more of a reflective comment because I know she's been on the other side of the equation and the prosecution side of this, but if you can just lend any insight or experience, having been on that side of the equation, of where you sit now, some of the compelling differences between the two.
Well, in the regulatory investigation, I'd say we, in some ways, have an advantage because the individuals who are coming to be licensed, so an individual that is wants an employee license or a vendor license or as a qualifier, they have to fill out forms. They have to.
Director, would you pull the microphone?
They have to fill out forms. They have to answer questions, so that it is an advantage for us because they are looking for something from us, and if they want to get the license, they're compelled to provide whatever we ask of them, and it's an effective tool to get information to have that power. You know, on the criminal investigatory side, you know, generally tools such as search warrants, wiretap warrants, immunization of witnesses, proffer agreements, witness cooperation agreements, those are some of the tools that that on the criminal side that may be effective in an investigation. So it's a different, it's different, although we do have a state police unit that's working with us who are experienced criminal investigators, and we may use, you know, some methods going forward, but generally we are looking at things from a regulatory perspective. Can we license them? What is the analysis of prospectively of can we affirmatively find that they will be okay going forward? Whereas in the criminal investigation, they're looking for evidence of misconduct. So it's a different, if it's a different intellectual analysis, and it's a little different in some of the tools that we use and some of the powers that we have.
I would also just reflect on the comments of the fact that, you know, we hear oftentimes that government agencies don't talk to each other, and this is certainly a fine example of where government agency cooperation between federal and state authorities, I think, assisted us in the work of the IEB, assisted them in return. So that's to be complimented, and hopefully something that we can continue to appreciate as this process goes forward.
Thank you.
All right, I think that does it. Thank you all three for your help, prior work, and your report today.